Welcome to Intellectual Property Matters. In this WIPO podcast, we explore the fascinating world of creativity, innovation, and intellectual property. Let's listen, learn, and get inspired.
Hello, everyone. Thanks for tuning in to the very first episode of Intellectual Property Matters. We're starting WIPO's newest podcast with a mini-series of classroom conversations. In Classroom Conversations, we invite experts, WIPO Academy alumni, and partners to give bite-sized crash courses on a range of intellectual property, or IP for short, related topics, and chat about the latest developments in the field. Today, we welcome Dr. Gaetano Dimita, a senior lecturer in international IP law at Queen Mary University of London, and an expert in his own right in the field of video games and interactive entertainment law. We'll be talking about video games and how intellectual property plays into this field. So to start off, I would like to ask a very important question. Gaetano, what would you say is your favorite video game of all time? And if it's too hard to narrow it down, maybe you could just say your top 3 favorite video games.
No, I have to say I spend a lot of time with World of Warcraft. I'm a big fan of the Warcraft franchise from Blizzard Entertainment. So I would say that that's the video game I played the most, and definitely one of my favorites.
What should I know the next time I play Subnautica or the next time any gamer plays their favorite game?
Of course, I live in an IP bubble. I would like everyone to know everything about IP because I truly believe they're fundamental. An understanding of what they entail is fundamental for everyone. But in particular in video games, since there's such rich IP creations, and they're not static in the sense films, music, you can just passively listen to this creation, to this form of art. With video games, there is an active participation of the player, and this active participation can be creative. And actually, there are amazing examples in the last 20 years of video games players that are sensation. They are or extremely good player, professional esports player, or they just play their video game in such an entertaining and unique way that they have millions of followers, of people that watch them playing online on Twitch. Of course, not everyone is a super pro or an entertainer. For instance, I'm one of the bad players. I mean, I'm not particularly skillful anymore in playing video games. But the way we interact with this form of entertainment does always have some IP coloring. So it is fundamental for me. I would invite everyone to do one of the things that no one does, to read the end user license agreement and the terms of services of the video game. Of course, there are different video games. I'm not referring to someone playing, a quick hyper casual game on their mobile phone. But it's very important when you start investing so much time, so much of your energy, so much of your passion into a video game to understand what are the IP aspects that might be relevant for you in any way. And these end user license agreements and terms of services, these documents are actually the constitution of governance of the video game you're playing. So it would be important to understand what are your rights, what are you entitled to do with that particular video game, starting from the object that you obtain or the object that you actually buy using your own money in order to access them in the video games. Because there are a lot of misconceptions. I mean, from the basic one, people say, I bought the video game, I own it. That's not correct. You buy a license to play the video game. So this has some consequences. It's not an issue of ownership. And it's the same with the object that you obtain in the game. Even if you put a lot of times, you put a lot of money, you pay a subscription fees, you tend not to own them. I mean, there is no concept of ownership of this items. You do have some remedies in case you lose access to the account or the video game is discontinued without proper notice. There are consumer protection law that can intervene, but it's important to understand. And in an environment in which video games are not only played, but the playing of the video game is shared on social media, there are a lot of players that get really involved with the universe created by the video games. And so they create fan art, they create stories based on the video games. It is important to understand what is actually allowed, what is licensed, what you can do with those video games. And even the tricky part, you want to play your video games on Twitch. It's important to understand if you can share everything, not only the video game, but also the music that is inside these video games. Because sometimes, these international global licensing structures, they are simplified in the end user license agreement. 20 years ago, I would have never suggested anyone to read them. They were really long, really often badly drafted, but they're getting better and better. They're a really nice example of a publisher that have a clear end user license agreement, and then they also have, a translation, a non-legalist translation on basically what you can and what you can do using those videos. And they also give you an understanding of what is the culture of the community in these video games. So what are the guidelines? And since you have this strong connection with your video games, are all aspects that I think are important to know. It's also a great educational tool, I guess, for the youth. The first contract probably everyone reads is an end user license agreement. Definitely the first contract we sign, the youth sign, is an end user license agreement. And most of the time they do it without reading, and this is bad. You don't want to become a Twitch sensation and then figure out that all your videos online are copyright infringement, and so they get taken down, and so forward.
Yeah, nobody wants to get a copyright strike on their videos of them playing games.
It's so stressful being flagged, and there are all things that can be avoided with an understanding. Most of the time, for instance, video game publisher are okay. They provide very clear license to the content creators, explaining to them in simple terms what they're happy for you to do.
I think it's so true what you said. Many people, their first contract that they sign is an end user license agreement. People just do it without reading the whole contract. They just click agree and move on to access the content and the game. And there is a easily digestible version for a regular person to understand that would make it.
And I honestly believe that is the key. And again, I want to make it as a societal educational process, because I'm 100% sure the first contract is an end user license agreement. But also most of the time, the first money people spend is on video game. When I say people, I mean younger generation. I don't think my first money was on video games. They were not really video games when I was a kid. But also the first people that they meet outside of their family circle tends to be through video games. And the first money they earn often could be on Twitch, on YouTube, because they're posting videos based on video games. Now we have video games that are actually, the game is to create other games. Roblox is an example. If you're playing Roblox, I would seriously suggest to read the end user license agreement. to see how does it work, how I'm going to end up, being successful with my game created on Roblox. And now it's really, really easy to design your own video game. So not only as a player, but as a player of a video games that allow you to create. And it's not only for the negative things, but also for the positive things. These community guidelines, this document that video games publisher are actually asking us players to sign, they are becoming a very strong positive tool. There are some of community guidelines that would be really nice to have enforced outside of video games. be an active member of the community for the sake of being a part of this community, because the more people are sharing and enjoying the game together, the better the video game community is going to be. Imagine the same conversation translated to whatever is outside of the video game. I don't want to call it the real world, because I do believe that the community game, they are real world too. But imagine if that was Twitter or Facebook community guideline, probably the world would be a little bit better. Yes, we can make the world better, a video game at the time, or more sadly, a contract, an end user license agreement at the time. We could actually create this positive outcome, because I do believe people want to be nice, and if actually it is a rule to be nice.
And just to break it down for those who are listening who might not know, what exactly are the intellectual property elements that are in the gaming world or in video games?
All of them. And this is actually the reason I'm so fascinated as an academic in interactive entertainment in general, because Those are very complex products or services that get distributed globally. I mean, the tendency is to have global distribution, of course, because of local regulation. There are a lot of times video games localized for a particular jurisdiction because the real saying on the internet, you're definitely going to infringe something somewhere. So there is a tendency to at least for some jurisdiction to localize, but they are so complex and rich, creative products and services that all the form of IP, they coexist, so can potentially coexist. It is a very rich IP environment. So video games can take from pre-existing intellectual property in order to recreate this pre-existing intellectual property. And that was kind of the story at the beginning. But now you see it inverted. Video games are the creators of new form of IP that then get licensed out to other form of entertainment. A lot of films, novels, music that is actually derives from the IP of a video game. Video games are becoming really central, probably because, and I don't know the cause and effect, but they are the most successful of the creative industry. I mean, the money generated by video games globally is insane. I think already 10 years ago, the video game industry generated more revenue than film and music combined. So they create new form of IP, and there is a constant creation of IP. And all the form of IP protection, they will apply. Of course, copyright is omnipresent. Everything that is original, of course, there are differences in jurisdiction on subject matter, specifically what aspect of the video game can be protected by copyright. But this, in Europe, for instance, if it's original and is easy determinable, that is protected by copyright. But then you have trademarks, very strong trademark protection in multiple aspects of video games. And not only, the name of the publisher, the developer, the title of the video game, and so forth, but objects within the video games, items within the video games, characters within the video games can be protected by trademarks. And more recently, with the possibility to register audiovisual mark, there are a lot of aspects of the gameplay that could be potentially protected by trademark. Patent is there because not only the hardware and the software, but increasingly an increasing number of game mechanics have been recognized patent protection. More in the US than under the EPC, but is there. They are invention. The fact that they are invention and they are in a video games doesn't prevent the possibility of getting a patent. And sometimes they are incredible invention. I mean, life-changing in Belgium. If you think probably the first 5 to 10 years of invention connected to the metaverse, this new incoming dreamland scenario. I grew up with Star Trek, and I want to see the metaverse for real in my lifetime. But most of the investment in creating groundbreaking technologies is led by video game companies, or at least companies that can see immediately a use of that invention inside a video game. Then, of course, there is design, and design is increasingly important at European level, if I'm not wrong. And the moment I say it, we're going to have a decision 24 hours later. But we don't have a court test on the enforceability of most of this design registration within video games. But it is a very powerful tool and is there available. And there are an increasing number of design registration for items within the video games, aspect of the video games and of the graphic user interface. And the list goes on, both for creative use of third-party intellectual property, and for the creation of the intellectual property per se. And sometimes it's also easier to codify what is protected within the video game than in general. For instance, when video games are created on the basis of pre-existing IP that are more text-based, more literally based, you immediately get, the graphic. You immediately get a translation of your imagination into something that is visible, creating millions of new subject matter of protection for IP rights. And when you also consider how realistic they are becoming, you get into personality right and right to protect the commercial exploitation of someone's images in case you're using celebrities or none in your video games. There is an increased use of architectural buildings or of real places in which use within the video games to get it much more realistic. And there you go into the sideline of IP. For instance, protection of cultural heritage is something that for instance, Italy has very specific legislation as a lot of other countries. They all become relevant because it's At the end of the night, video games for me is where the purest form of creativity meets the latest technology, the most futuristic technology, and immediately gets distributed in a global environment. So IP is everywhere. It's not only the blood, thinking of the money, but it's also the soul. And then, of course, trade secret. I mean, you name it is very relevant to IP. Unfair competition, extremely relevant to video. They are not games. That is the bottom line. They are not just a form of entertainment. They are very creative and interactive form of entertainment. And of course, you get the license, you get access to the video games, you start playing. But remember, what you're doing while playing can be creative per se. Can be another layer of human creativity on top of a very creative subject matter. And I hope I'm going to spend the rest of my life doing research in this field. It's fascinating. Every time there is a problem or there is something that tickles the curiosity, has immense economic consequences for the distribution of the video games. It's often the case that no one asked that before. So it's the first time that thing is happening.
I'm curious as to cases where one video game kind of oversteps on the territory of another video game, if there's an Easter egg.
Yes. I mean, it's actually, since it tends to be the funniest case and the most complicated one, we discuss them a lot. On one side, of course, there is the crucial difference between copying something and being inspired by something. It's really difficult to draw that line. And video games are a very complex ecosystem with thousands and thousands of creators worldwide. And it always, I mean, and this is the classic lawyer answer, it depends. We go from cases of cloning got bad. I mean, video games that are just created to recreate and to free ride on the success of pre-existing video games that tend to be the result in intellectual property infringement, whether it is copyright, trademark, or fake unfair competition. So there are those extremes. But video games takes from popular culture and they became popular culture. So it's not uncommon to have Easter eggs that are potentially infringing and then nothing happened because it's a community of creators. I mean, we have always to remember we started really early on, and it's whichever date you assign to the beginning of video games, you get it wrong. There are so many different opinions and theories on which one was the first video games, which one was the first commercially successful video games. So let's put it 80s, early 80s. The video game phenomenon started. It was a culture of cracking, yakking, copying, do it fast, doing it well, focus on the result, and it's a very shared community of creators. So I mean, there are differences. That's probably, but this is my personal opinion. The reason, in some cases, these things they don't get enforced, even if there is potentially an infringement. Sometimes, however, they go to court. There is a tendency, especially from industry outside of the video game industry, to try to enforce. And there have been very important cases in the last 20 years in which the line between using something creatively within the video game for a specific reason, so, the artistic value, the artistic freedom on one side, and then the unjustified use of a third-party intellectual property law had gone to court. I mean, there is a very important decision from a couple of years ago, AMV, in the US, in which the court actually showed that in order to create a war game in which you are playing mission in a war zone, in a modern war zone, the AMV, that very famous Jeep from the USA Army, has to be there. Otherwise, it wouldn't be realistic. It wouldn't give you the same sensation. You will feel something is off if that's not present. So this is one extreme, but yes, American case. You want to have an Easter egg or a cameo. If it's funny and you consider it cool and you really want to have it in video games, so some publishers, they risk it. Some others, they are totally risk averse and they try to avoid it. We saw, for instance, what happened with Dance Move in the US. So many cases were filed against really famous dance move using video games. Most of them were dropped at the end, not because actually the legal analysis and understanding, quotation, for instance, or would that be considered as quotation? Are there any limitation exception? Can a dance move, a dance routine be protected per se? These are micro questions. We do have some answer. depending on the jurisdiction, we have some clarity. But those are 11 or 13. I mean, a number of cases being filed in the US, and none of them at the end went to court. On the other side, you have video games that fail launch because they got in trouble. They forgot to clear a trademark, or they didn't want to clear a trademark, or there were issues, for instance, in the promotion of the video games using a character that was easily recognizable as a real person, and that was not authorized. So there are thousands of cases, and of course, the spectrum from okay, it's funny, it has an amazing joke, everyone is gonna love it, even if there is, the character is protected by copyright, to you're gonna fail to launch your video games because you didn't clear your IP. So it is an analysis that you have to do, and it's becoming extremely complicated and time-consuming to do this analysis. Imagine, this open world that reproduce a futuristic environment with millions of images, screenshots, with logos of companies, with fake companies, with music that is created only in the video game because the band is a character in the video games. No one wants to infringe anyone's right. That is the basic thing. You try to do it as best as you can. But even think about trademarks. If you create a fake company in your video games and then you have to check everywhere whether or not there is a similar trademark registered anywhere on the planet. Thank God now we have online databases, all they are searchable, and but still, it is something you have to do. And for instance, if I can make an example on trademark, it's fascinating because now we have very successful trademarks with connected merchandising of companies that only exist in video games. So there are t-shirt series, there are mags, there are leather jackets with logos of companies that are only in successful video games.
I mean, video games really are part of pop culture, and they contribute to pop culture because of their interactive nature in terms of the users, the players, and the content that is generated there. And it makes me think about Roblox, for example, which is a platform where gamers can create their own games and then they can play each other's games. So it's basically a user-generated platform for games. And I feel like that's going to create such a murky territory for IP there. What would someone who's active on Roblox need to know?
Every time we try to translate to the general user the complexity of IP, there is a risk of getting something wrong. User-generated content are crucial to the video game community. I mean, video game players, they have a tendency to understand the technology, know how to use a computer. They tend to be very creative people. So even before, something like Roblox, you could play around with Unreal or Unity and design your own video games. It's just there wasn't the social media factor that probably Roblox has been introducing. I've seen amazing things done on Minecraft. I mean, actually, Minecraft predates Roblox in this possibility to give user the power to enjoy the game as they want it. There are amazing things have been done. But when this IP complexity is done business and businesses, so developer publisher or different publisher, different developers, of course, they do have IP support. They do have IP expert that give suggestions. Of course, then the final decision is always business. You just give alternatives and you give a risk assessment when something needs to be done. When we're translating this power to create and commercialize a video game to the user, you always encourage them to risk, or that you don't do it properly as a licensing structure or the structure of the video game, or you didn't anticipate some things that could happen, or sometimes there are things that you cannot authorize user to do, and so you tend to be silent on that aspect. And this creates complexity because the moment it becomes extremely popular and extremely successful, then is where the problems start arising. I don't know if anyone ever tried, but what you can and what you can do when the monetization from the providers start happening, what are the rules, integration with third-party software, but they're really, really long license, and except developers or lawyers working for the developers have a look and explain what these terms actually means in practice, there is a risk of misunderstanding. But then, if you move it to Roblox, there is an end user license agreement that is complex, determine everything that is going to happen to the video game you create within Roblox. And Roblox is, I don't want to give any answer on Roblox because it's something that is the focus of my research. Also because I look at it as one of the precursive environment that is going to lead the way for the metaverse. This is so basically, yes, a lot of the things that we expect to happen. And in particular, what I'm really curious about is how they're trying to create some governance for the user creation. With Roblox, we actually, and you pointed out correctly, we're looking at a platform that allows. And I'm leaving the sentence, I don't complete the sentence, allows what is another thing that I'm really curious to figure out, because what is the service that is being offered? To what extent there is a governance of the platform over the creation and the community within the video games? And how we will look at Roblox in the future, or of this platform that allow us further creation of communities, because then you get into one aspect is the creation, one aspect is the derivative creation of the user creation based on pre-existing IP, also dragging from intellectual property from outside of this particular universe. And then within that video games, the possibility to mod, to create add-ons, to add your own creativity to a video game that is created by a user using third-party software on a platform that is run by a publisher. And at the moment, I'm still mapping. I'm still trying to find, the research question to look at it properly. And when I say properly, it's because, of course, I'm not part of the video game industry. I'm a player that happens to be a researcher and an academic. I'm much more curious in how this could be done in a way that is human-centric. I would like, especially now that we still can, to refocus everything on the user, because the license can be created perfectly for the platform to protect the platform from liabilities, to allow the platform to perfectly monetize on the creation of the user that participate in this environment. But I think as an academic, I would like to focus my interest on us using those platforms. What are the consequences for us? And Roblox has been amazing. The fact that there are so many younger people that are actually getting into, at the end of the day, a form of computer coding to create a video games, and then thousands, hundreds of thousands, or even millions of people, they play those video games, and there is already an IP pipeline created. That's already amazing. The other question are still open. For instance, there is a lot of concern in regulators for this particular platform because, of course, they're underage players, they're underage creators. And as for the early days of another platform, the internet, there is a tendency to decide everything in order to avoid liability, to avoid problem, to push away anything that go wrong. And here's where the discussion is going. I think almost everywhere, all the jurisdiction I follow, there are ongoing discussion on they are becoming very powerful platforms that allow social media platform. They are becoming, in a sense, social media platform. We should follow them. We should try to understand. Personally, and this is the question most of regulators forget, whether or not there is anything that needs to be regulated. But I think it's because of their societal impact. It is really important to have clarity. And sticking to IP, because this is my area of expertise and what I love, I don't want to get into other form of regulation, of community regulation, online regulation. But in IP, I think it is fundamental that through video games, we actually teach and make people understand how important intellectual property law is. There is the WIPO series on making a living out of video games. You can. And you can creating a video, that's a basic old school way of it. But there are so many professions that you can embrace by playing video games. There are a lot of successful stories. Next generation tend to be more tech savvy than the older one, and this platform are actually teaching people to design video games. That's amazing.
Anyone who's curious about that, WIPO has a lot of resources, like you said, the publication, How to Make a Living from Video Games, which you helped contribute to. And also we have courses at the WIPO Academy, which cover basics of IP that could be of interest to anyone.
I myself, I'm proud when people ask me what I do, and I tend to answer, I teach video game. I cannot leave the law part out. Something that really makes me happy. I mean, it was something that started as a hobby and now could be the main source of income. And of course, I mean, not everyone is going to end up teaching video game law, but I mean, it is a thing that, for instance, in law school, didn't exist when I went to university. Now it is a course. I mean, you can specialize in interactive entertainment law or video game law in some university. That is incredible. And the saying, probably your kids will do something, they will have a job that doesn't exist at the moment. It is very true. Technology is evolving so fast. That probably the next generation, they're gonna do stuff we cannot even imagine now. And so video games can be the key to access this forward-thinking environments. And the fact that now with Roblox or with other, moral school, programs, you can actually do it yourself. You can actually have an idea for an amazing adventure, and you can actually show first your friends, your family, or put it online and have other people playing what was originally just in your head. I mean, 30 years ago, it would have taken a team of numerous people with different skill in order to transform your vision into something playable. You have to put your time in and you have to learn how to use the software, but it's so much easier. And this is giving us a lot of amazing IP in playable experience. I mean, as you can hear, I'm particularly passionate about the topic.
Many people are passionate about this topic, and it would be great for them to tap into it.
Yeah, and I think the link is being shared on the WIPO website. There is the second edition of Mastering the Game. So if someone wants to learn more about it, and it's free to download. This is one of the amazing things of the WIPO publication. They are there for everyone that wants to read them.
And also, if anyone wants to learn more about what IP is and the basics of it, a great starter course is the General Course on IP, the DL101, which is a WIPO Academy staple. So those are also available resources for those wishing to learn more. But this brings us to the end of our classroom conversation for today. Thank you so much, Gaetano, for all these awesome insights into video games and the industry overall. And most importantly, I want to thank our curious listeners for tuning in. And we'll catch everyone next time on Classroom Conversations. Thank you.